Welcome back to Crime in Court. This is the 1996 Menendez brothers retrial. California versus Erik and Lyle Menendez on trial for the homicides of their parents, Kitty and Jose. We are nearly through with the state's case. We are almost through. This guy has been on the stand for several days, and his cross-examination with Leslie Abramson, the defense attorney for Erik, has been a little brutal, but we're getting through it. He's very evasive, doesn't want to answer questions, doesn't want to admit to um, anything that he might have misinterpreted or, you know, been wrong about. So that's kind of where we're at. We're still in the middle of his cross, or rather, we're coming to an end, I should say. We're almost done with him. So let us please get started and hit the like button and share, like, do all the YouTube things, please, as it does help the algorithm and helps get this out to more people. All right, so the jury is back, the court says. We'll continue with the cross-examination. Ms. Abramson says, "Thank you, Your Honor." And she asks, "Dr. McCarthy, on the beginning of your direct testimony, you indicated that you had contacted the Fiacci Firearms Company." "Ammunition company, yes." "And where did you contact them?" "In Italy." "And is it your testimony that they told you that they had discontinued manufacturing the type of number 4 buckshot that was actually used in this case?" "No, my recollection is that when we contacted them, they could not tell us what runs at various times, basically." Sorry, let me try that again. He says, "No, my recollection is that when we contacted them, they could not tell us what runs at various times basically consisted of in terms of internal construction. They just didn't keep records like that." "Well, didn't they tell you that they are still actually manufacturing number 4 buck loaded both in the way that it was used in this case and in the way that it's loaded that you purchased?" So some of them have like the specific wadding, some of them don't. He says, "I don't remember getting that information. Nobody there spoke English, so I had to have the library do it with an interpreter. I didn't talk to them directly. I don't remember getting that piece of information, if in fact that is true." "You didn't actually talk to them at all?" "That's correct. No one spoke English." "If we spoke to someone in Italy yesterday morning who spoke English to us, are you telling us you didn't reach the same person?" "That is correct. So they called and got someone who spoke English." "And then did you talk to Fiacci of America, their main headquarters here in the US?" "Yes, we initially started there." "And they referred you to Italy?" "Yes." "And what are you relying on, by the way, to form the opinion that Fiacci ammunition was used in this case?" "I haven't expressed that as my opinion. I think it was asked about that a couple of days ago." Or he was asked about that. Yeah. It was testified to that that's what it was. But he's now saying, like, he's not even saying that in his opinion that's what was used. He says, "As I've indicated, I've made an independent attempt to verify the type or manufacturer of the ammunition. It hasn't played any part in my opinion." "Well, you said you were going to try to buy the same ammunition. Wouldn't it help to know what it is that you're trying to buy?" "No." His answer is just straight up no. "I said if the technique had worked out. In other words, I had a hypothesis that I could reconstruct the shots based on groupings and distance shot from a similar ammunition. I was wrong. So I don't see how to reconstruct shot distance based on shot spread. It's too variable, shot to shot. Forget gun to gun." Damerson says, "I'm going to object. Move to strike as totally non-responsive." The court says the answer will stand as it is. "Your next question, please." Ms. Abramson says, "Thank you. Did you have in mind a type or brand of ammunition that you were going to use for experimental purposes?" "Yes. Fiacci number 4, that's what I originally bought. having only read the testimony. Well, that's where we're getting to. And who testified to that Fiachi number 4? I don't remember specifically who, perhaps Detective Van Horn. I I don't have a specific recollection. Have you had an opportunity to go back and look at the materials that you told us were submitted to you, that list you gave us, to see who, if anyone, in those materials mentioned anything about a maid at the Menendez home? I mean, I had an opportunity. I could have done it last night. Have I done so? Again, the maid played no part in my reconstruction. The question was, where did you get the information? As I sit here, I cannot recall. Did you have in mind when setting out to attempt a reconstruction of this incident that 12 rounds were fired? No, I could care less how many rounds were fired. Did you believe that it was uncontroverted that 12 rounds had been fired? You know, it's tough to go back in your belief system. At one time, I certainly thought that that was the number people thought. But I mean, that certainly wouldn't have driven the reconstruction. Whatever it came out, it came out. Again, with those answers, whatever the answer is, it is. That's just how he likes to answer things. Ms. Abramson says, move to strike. The second half of the answer is non responsive. Overruled. What's up, Judge? Like, okay, whatever. The judge irks me in this case, if you can't tell. Ms. Abramson says, did you, at the pretrial hearing on October 2nd and 3rd, testify that you believed 12 rounds was an uncontroverted fact? I believe in cross-examination. When you asked me about that, I might have said that, but because at one time I certainly believed that the thought was it was 12. But now, you prepared your report on July 13th, 1995, and understood that at some point thereafter the report was given to the defense, correct? I assume so, yes. And then there were contacts trying to arrange conference calls so that various members of the defense could talk to you about your report. Do you remember that? Yes. And in the course of those contacts, you indicated that you had done this target shooting, correct? I think I did, in response to questions I was asked, yes. And in response to a request for material, you prepared Xerox copies of the target, the board targets that you had made the holes in, correct? Someone requested copies, so I had my assistant copy the targets that I shot. And those copies were sent to the district attorney's office. I have no knowledge. He sent them wherever he was asked to send them. I want to show you. These are the paper targets that you shot, correct? And we've previously marked them all. Yes. And showing you what was previously marked 283 is that one target that was shot with a different Mossberg shotgun than the one that you brought to court and that's now an evidence item. Yes, this is a Mossberg 500A with a different serial number. It has a serial number that begins with the letter J, correct? Yes. And the other one, the one that's an item of evidence here, is a K. Number serial, correct? Mine is K, yes. Well, is yours the one you brought to court? Yeah, I mean, you think it's still yours? You think we're giving it back to you? I'm not very optimistic, but the one I brought has a K, yes. Now, I just looked through all the targets. Do you recollect that you shot more than one round with the other Mossberg, the J-numbered Mossberg? I don't have a recollection. I thought I just shot out I thought I just shot out of two. You shot out of two guns? Yeah. And you want to look through these to verify that there's only one target from the J-numbered gun. You are correct. I noted the serial number of the weapon on each target. Showing you a package of Xerox copies, I'd like to mark the package collectively next in order. I'd like to actually mark the disassembled shot shell next in order. What I'd like to do is mark an envelope with the number and put both components in the envelope, both the shell and the pellets. Does that make sense? The court says you want it all together in one large envelope. What happened to the powder? Did you want that as well? Miss Abramson says, that should be part of it as well. We'll mark them all collectively with one number. Court says, okay, 305. Miss Abramson says, I'm putting 305 on both of these envelopes and I'll add the third one. So I would like to mark this package of documents Xerox copies 306, Your Honor. The court says 306. Ms. Abramson says, Dr. McCarthy, do these appear to be the Xerox copies of the targets? Yes, sir, they do. Thank you. I have nothing further. Finally, cross-examination is over. And of course, there's going to be some redirect because she basically destroyed him on the stand. So, all right, we're going into redirect. Mr. Khan for the state is going to be asking the questions. Dr. McCarthy, you said that you did not consult with a criminalist or a pathologist before reaching your conclusions in this case or preparing your illustrations. Can you tell us why you did not do so? Objection irrelevant. Overruled. My understanding is there were already criminalists, and my role was going to be as an engineer doing the reconstruction. So I approached it as an engineer doing a reconstruction, which is what I understand how to do. Since the time that you reached your conclusions and prepared your illustrations, you've heard the testimony of Dr. Lawrence, have you? Yes. Well, some of it, yes. You also received additional information, such as the distance from the French doors to the tree outside of the lawn. Is that correct? The precise measurements, yes. Has any additional information that you received in this case to date caused you to change any of your conclusions or opinions? No. In my view, it's been remarkably consistent. Object, move to strike, non-responsive, conclusion and opinion of the witness based on expertise. And the court overrules that because that's just where we are. Mr. Khan says, now, in this case, doctor, you saw from the illustration of the crime scene that there was wadding that was recovered by the Beverly Hills Police Department scattered throughout the room. Ms. Abramson says, I'm going to object to counsel leading and testifying. The court says, just a preface to the question to focus it. So, overruled. Mr. Khan says, does the location of that wadding assist you in any way in determining the locations from where the shots were fired in this case? No. And why is that? Too much of it. Too many shots. And also, if you get a couple more of these targets, the wadding, I mean, some of the targets I showed there was actually wadding holes in a different place than the shot group. Wadding actually can go off in different directions, and even the shot that expelled the wadding doesn't follow the trajectory of the shot. It can go off at a different angle. It doesn't go backwards. After it hits something, it can go backwards. There are just too many wadding bouncing, or too much wadding bouncing around the room for me to use it reliably. Does that sound like a scientific explanation? There's too much wadding bouncing around the room. Okay. During your examination by counsel, she showed you what appeared to be a communication from yourself to another person. Do you recall that document that I'm referring to? Concerning my American Society of Mechanical Engineers paper? Yes. Okay. And I don't know if that's been marked. The court says, I don't believe it has. Mr. Khan says, perhaps if counsel has that document, I can show it to Dr. McCarthy again. I'd like to mark the document as well. Ms. Abramson says, I'll find it for you, counsel. I have a lot of documents. Court says, it's $2.99. Ms. Abramson says, did I give it a number? Mr. Khan says, that's a different document, Your Honor. I just had that one pulled. Court says, okay, that's a different one. Ms. Abramson says, I'll try to find it. It's here somewhere. Why don't you go on, counsel, so I don't hold you up? I'll find it. Mr. Khan says, do you recall the purchase for which that communication was written? The purpose for which that communication was written. Yes. And can you tell us what that was? Yes, this was a paper that I was working on with 4 other individuals at Failure Analysis. It ran about 20 some odd pages and it was going to be peer reviewed, and it dealt with statistical analysis of large scale accident data sets involving all terrain vehicles. Those are motorized 3 and 4 wheel vehicles, straddled ridden cycles. This paper dealt with the accident data and methods of analyzing it, particularly for control of multiple simultaneous variables, and so it was technical, and I think I was the 4th author. So the paper had been written and edited by the 3 authors in front of me, and I was putting in my edits, but I was editing on the road, editing a few pages and faxing them back. Okay. And do you recall the phrase in that document? I don't think the document has been found yet. Do you recall the phrase that counsel directed your attention to in the document? Yes. And what was that phrase? My phrase was concern over the example being used to confuse juries. He used the words to confuse juries, excuse me. Ms. Abramson says, I'm going to object and move to strike. He's asking what phrase he used. Those weren't the words written. The court says, overruled. If you could find it, it would help the witness answer the question. Ms. Abramson says, I know. If counsel wanted me to find it, he could have told me earlier. The court says, your next question, please. I love her sass. Mr. Khan says, and can you tell us what you were referring to in that phrase? Yes. Do you have your own copy of that document? I have my own copy. Miss Amerson says, oh, then he doesn't need mine. Can I approach Your Honor and make sure that the witness's copy and the copy that I'm trying to find are the same, and we can use the witness's copy? The witness says, surely. Like he's the judge. She was addressing Judge Weisberg. Ms. Abramson says, yes, you can go ahead and use his. It's the same. Mr. Khan says, can you tell us what that phrase was that you were referring to? Sure, I said. However, would you like me to read the whole thing? Yes, the whole thing. Quote, Bill says, I understand the purpose of this example and think it is instructive. However, this example will be used to confuse juries when I testify in kids' cases. Can we find an example that works the other way? That is, the gross number is higher than the single adjusted number. And what were you attempting to communicate in the use of that phrase? Will be used to communicate to confuse juries. This was a single variable, uncorrected analysis of the correlation between risk and engine size, not controlled for any other variables, and particularly in a subject like motorized cycles, you not only have to control for engine size and driver age, you have to control for the nature of the suspension, the type of vehicle. Okay, so that wasn't even an answer, but that was just like a bunch of word salad. He goes on, though. There's a number of other variables you have to control too. I was concerned that in cases where we had a controlled analysis that would trot out the paragraph and say, didn't you say it was method X? And now we're saying it was a correlation. Why? No, 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 no. When you find a control for all the variables, you have achieved the correct correlation. Absent that, you have an uncontrolled analysis. What I was suggesting is that you actually find a counterintuitive example where uncontrolled worked the other way and show how the control strengthens it out. That was a lot of word salad. And I can't believe that the judge just allows him to continue on and on and on. You were suggesting it might be used by who to confuse jurors? On the next paragraph, I write the following. Next page on the same document, quote, this graph will be used by manufacturers to confuse juries and show our controlled analysis. The way I wrote my editing and show our controlled analysis completely is wrong. If the high side were on the greater than 30, uh, were on the greater than 35, no problem. I'm just reading the words. The next question is, so you were suggesting it could perhaps be used by the other litigants to confuse the jury? Exactly. That was my concern. Okay. Now, you indicated in your testimony that you did not let me direct your attention to one of the photographs referred to by counsel. Directing your attention to this middle photograph, to the dark marks on the arm there, you indicated that you did not illustrate on your diagram wounds reflected in that photograph. Can you tell us why you did not illustrate on the diagram such marks on that arm as depicted there? The court asks, what exhibit number is that, by the way? Mr. Khan says, it is exhibit 1B. Court says, it's not 1B. The witness says 301. Court says 301. Okay. The witness says, those wounds in the right side of the center photograph on the right forearm have, in the currently revised coroner's report, disappeared. That is, the revised report does not mention wounds there, and I don't have a picture of the cleaned up body showing wounds there. All right, I'll get back to that wound a little bit later when we go through Dr. Golden's report with you. I have a photograph, Your Honor, which has not been previously marked. It is a photograph, a copy of which is contained on the CD-ROM provided by counsel, provided to counsel. Ms. Abramson says, you want to show me which one it is? And the witness says, this is one floor. Ms. Abramson says, may I consult with counsel? Mr. Khan says, I would ask that. The court says, number 307, thank you. Mr. Khan says, doctor, if you would, at this time, turn on your computer, and if we can hook up that projector, I'd like to be able to project this photograph to the jury. Ms. Abramson says, we would only ask it be projected in its standard form, not enlarged. The court says, same form it appears on the CD-ROM. You'll need something to project it onto. Ms. Abramson says, Mr. Khan, you'll have to move this board. Mr. Khan says, if we could dim the lights momentarily, I would like to ask you if you see in this photograph the dark spots which you said appears to depict some tissue or flesh. Yes, you can see right there. And he points. There are 3 things you can see in this photograph more or less in a line. Well, which 3 things are you referring to? You see this tissue here, and he points. Ms. Abramson says, I'm going to object to the witness saying it's tissue. He's not qualified, and you can't see it clearly enough for a layman to say. And the court overrules that, because of course he does. And he asks, do we have a pointer somewhere? Keep telling us about this tissue that you're not qualified to testify it as tissue. And Ms. Abramson says, I don't believe he has a basis for such an opinion. The court says, where's the pointer? He just ignores her. The witness says, to qualify the witness's answer, it appears. Oh, the court says, where's the pointer? The witness, to qualify the witness's answer, it appears to the witness to be tissue. Ms. Abramson says, thank you, Your Honor. So he's not saying it definitively is tissue, although I don't know if that's a great curative, but that's what we've got. So Mr. Khan says, what 3 things were you referring to, doctor? You have what appears to me to be tissue here. You can see here the red pixel there, what appears to be blood there. Ms. Abramson says, objection, Your Honor, no foundation. Overruled. The witness says, we did end up with a wad here. Mr. Khan says, all right, thank you. You may return to your seat and raise the lights once again. The witness says, do you want me to turn off the image? Mr. Khan says, yes, if you would, please, thank you. The court says, you want to circle those on that exhibit 307 so that we have reference to here. The witness says, can I put 1, 2, 3, or 1? I have circled what I testified appears to me to be tissue. I have circled and put a 2 next to what appears to me to be blood, and I have put a 3 next to what appears to be a piece of wadding. Mr. Khan says, "Thank you. I think we can turn off the projector. I would like to refer you back once again. At this time, I believe for you this may be the first time this has been presented. A portion of this exhibit 243, that is this pellet count. I'd like to clarify. You indicated that you came up with a count of approximately 27 for the pellets that were recovered or at least viewed in the x-rays and or recovered from the victims' bodies. I would like to ask you at this time if you would indicate for us which figures you were relying on in that pellet count." Well, when I did mine, and once again I'm comfortable with, as I indicated, Dr. Lawrence, there were 2 x-rays where I differed with his count. X-ray number 9, I think my count was 8, and in X-ray number 3, I counted 8 here and 13 here, and I agreed with him. I ignored that one. Okay. And I came up with 27 too. So they counted different things, but they got the same number. So that makes sense. Okay, so when you say there was 8 in X-ray 8, would that be in reference to the right arm of Jose Menendez? That's right. You said that you came up with 13 or X-ray 3. No, no, I came up, excuse me, yes, I'm sorry, 13, I'm sorry. Would that be in the breast of Kitty Menendez? Yes. When you say you came up with 1 for Jose Menendez's chest? No, I didn't think the chest was associated. I don't think Dr. Lawrence did either. Ms. Abramson says, "I'm going to object, move to strike. It misstates Dr. Lawrence's testimony." The court says, "All right, that portion referring to Dr. Lawrence is stricken. His testimony is in the record." Mr. Khan says, "The one that you were referring to then was that the left arm of Kitty Menendez." I had one, he had one. Huh? And then that gives us a total of 22. And for the remaining 5, would that be the 5 that was recovered from the left elbow of Jose Menendez? Yes. Now I would like to redirect your attention to another exhibit that has been presented by the defense, and that is an exhibit depicting a trajectory going through the remote control of the sofa. Do you recall which one I'm referring to? Yes. Now, can you tell us why it is that you disagree with that illustration, and if you perhaps it would assist you if we were to use a sheet of paper at this time that would help you illustrate what it is that you disagree with. Let me mark this at this time as 308 using a pen. If one is there, could you to go to the board and indicate to us what it is that you disagree with? Yes. What it is, it's an artistic. Let me see if I can find the other photograph to use. It's not here at the moment. Miss Abramson says it was a small attachment, Mr. Khan. The court says it was an 8.5 by 11 sheet of paper. Miss Abramson says, yes, it was. It might have been 297. Ms. Nahara says, we have the tag, but the tag came off. That's why we can't find it. There it is. Mr. Khan says, all right. Directing your attention to 96 and 97 is the top one, and immediately below, I'm putting 296, both of which depict on the sofa the remote control, the top one appearing to intersect with it in some way. Could you tell us why you disagree with that illustration? Yes, it's an artistic misimpression given by drawing a three-dimensional construct in 2 dimensions. Okay, and can you tell us what you mean? Would it help to make a drawing if you can illustrate what you're referring to? I'm not the best artist in the world, but I can illustrate how you would do it. Okay, all you do, let's say we have an object, a rod in space. This will be a three-dimensional rod. And behind it, it's going to be over the top of the cube, which I'm now going to draw, not a cube. Let's just make it a flat. Okay. What is he talking about? What I've drawn here is a rod just above and off to the right of a square block. Now let's draw that same object, and this is where my artistic lack of skills is going to start to show. It already did. I'm going to draw the same side, the same rod, and I'm going to continue this line. Now, what I mean to do is sort of draw the same. I should have brought the space of block down a little further. What I'm trying to do is represent the same geometry, but now I'm just going to change one detail of how I draw the side of that rod. Now I haven't done anything moving the two objects, just how I've treated the detail of the intersection of the side and the corner. It gives your eye a different impression. That's what's been done here. The rod has been truncated around the channel charger to give the impression of intersection. But if you look at the picture, the elbow is clearly well above. It's not intersecting, but a rod of that diameter would not have had that intersection, that truncation. That's a misperception created by notching the rod. Created by notching the rod. Whatever that whole word salad was. Okay. Thank you. You may return to your seat. I believe that during your testimony you also referred to the possibility of drops of blood at the crime scene being consistent with drops of blood that were observable during the transportation of the body of Jose Menendez. Do you recall that? Yes. I'm going to object to counsel misstating there's no reference to transportation moving the body. Mr. Khan says yes. During the movement of the body, he just said it again. During the movement of the body, did you make reference to the observation of some drops of blood during the movement of the body at the crime scene? Yes, drips of the body that I had recollected seeing on plastic from body movement at the crime scene. I have another photograph that I'd like to mark at this time as 309. It depicts the body of Jose Menendez, which shows him lying on his back on a sheet of plastic. Showing you 309. Is this the photograph that you were referring to? Yes. Can you tell us? I know this is too small for the jury to see at this time, but if you can, as best you can, using the pointer, trying to. I think I can project that picture. It wouldn't be enlarged, just project it. Well, let's do that, he says. All right, if you can turn on that projector once again. He says, can I see the picture so I'm not guilty of enlargement? Okay, yes, I have this picture. Okay, if you can set up that projector once again, can you tell us what you were referring to when you made reference to drops of blood on the plastic? Yes, you could see. Miss Amerson says, Your Honor, I'm going to object to the witness speculating what others could see and just point to what he thinks he sees. The court says that's basically what he's doing. The witness says, we see here in this picture, Miss Amerson says, I'm going to object to the form of his statement. Overruled. Miss Amerson says, we see. And the court says, go ahead. The witness says, I see in this picture what I believe to be droplets of blood here. I can blow it up and enhance the picture, and I believe them to be blood. Ms. Abramson says, move to strike the statement about blown up and enhancement, and move to strike his statement altogether if he was relying on something we haven't seen. Overruled. Let me direct your attention to one more thing while we have this photograph up. On the right side of the body of Jose Menendez, there appears to be a lot of black spots along his torso. Do you see what I'm referring to? Yes. Are those pellet holes there? No. Can you tell us what that is? Again, from my view of this picture, this is dried blood, coagulated blood. All right, thank you. You may return to your seat, and once again, I think we can turn the projector off at this time. You made reference in your testimony this morning to star crimping, sorry. Um, is star crimping of shotgun pellets the most common form for closing shotgun pellets today? Oh, yeah, cheaper. Do you know what extent the so-called oval wad is still used in an alternative to star crimping? It doesn't. It's a question of the manufacturer. Many times they roll them. Ms. Aronson says, Your Honor, I'm going to object to anything after I don't. The court says sustained. Mr. Khan says, I would like to ask you a question now in regard to the item concerning the wound to the shot, which you indicated struck both the left elbow of Jose Menendez and also struck the right arm of Jose Menendez. Just to clarify, were you saying that in that shot the pellets came together to cause the wound? I'll direct your attention back to Exhibit 301. The top center photograph in Exhibit 301 depicts the right arm of Jose Menendez, the large wound to his upper right arm. Are you saying that after striking his left elbow, the shotgun pellets came together to create that large defect in his right arm? No, not at all. Okay. So now it was part of your testimony that the shotgun pellets in this case caused not only the wound to his left elbow and that wound there, the large wound. I'm going to object. There's been testimony that that it is a dissected wound. I'm going to object this as misleading. Overruled, of course. You understand the wound I'm referring to, the one you have testified to in this case, the one as being the large wound to his upper right arm? Yes. And did you also note that there was 6 individual defects just beneath, which now appears to have been dissected and opened up in this photograph? There were individual defects below it, yes. And is it your testimony that it was a single shot which caused the wound to both arms? I believe it a single shot, yes. Now, is it your testimony that some of the pellets came together to cause a large defect, while others separated to cause the 6 individual defects in the right arm? No. Okay, so could you tell us then why, in your opinion and for purposes of your illustration, you concluded that the same shot could have caused both the individual pellet defects on the right arm as well as the large defect which is depicted in that photograph? Because the shot continues to expand, which it does. It doesn't always expand uniformly, so when you have a hit at some point in a target, you can have a group of shot that will take out a section where you can have individual indications around it. And so I believe it's a non-uniform uniformity of the shot. It's a constantly expanding pattern. The pattern never shrinks back. Some of it strikes the left elbow and is filtered off. It strikes his right arm, some of the shot is together and takes out and creates what I believe is the large defect. Others of the continually expanding ahead pattern are creating the individual defects you see right next to it. Okay, I'd like to show you what has been marked as 219 in this proceeding, an illustration that Dr. Lawrence prepared while he was on the stand. Sorry, I'm struggling to put the blanket on the dog and scroll with my left hand on the mouse. Does the illustration assist you in any Does the illustration assist you any in explaining to us to what you are trying to explain to us? Very poorly worded. Yes. How is that? This illustration that Dr. Lawrence drew of a large defect surrounded by smaller defects is precisely what I'm talking about here. And you were asked some questions about the opinions of Dr. Golden, which ones you relied upon. Let me ask you this. Did you assume for purposes of your reconstruction regarding the shot to the head of Jose Menendez, did you assume that his head would have been thrown backward and remained in a forward position by the shotgun blast? Samuelson says, I'm going to object beyond his expertise unless such a reference is in Dr. Golden's report or Dr. Lawrence's testimony. Overruled. The witness says no. This is the point we were discussing earlier today about the misconception of people struck by a shotgun blast are knocked down or pushed around. It does impart some velocity, but it doesn't. I know there's a misconception about that. Mr. Khan says, okay. And do you recall the testimony of Dr. Golden before the grand jury that there could have been? Ms. Abramson says, I'd like a citation, Your Honor. Mr. Khan says, yes, I believe it's 123. Ms. Abramson says, I would also object to hearsay. Overruled. Do you recall the testimony of Dr. Golden before the grand jury that such a shot could cause a reflex jerk of the head backwards? I don't recall that specific testimony, but I don't disagree with that. Ms. Abramson says, move to strike since he doesn't recall it. He doesn't have, or he couldn't have relied upon it since he doesn't recall it. The court says sustained. Would the testimony, Ms. Abramson says, I'd ask the jury be admonished to, and the court says the answer is stricken. Thank you, Your Honor. Mr. Khan says, would the testimony of Dr. Golden that a head wound of this nature would result in a reflex jerking of the head backward be consistent with your opinion? Ms. Abramson says, well, Your Honor, I'm going to object. He doesn't have the expertise to decide that. Overruled. He's not a mechanic, or he is a mechanical engineer. He's not a biomechanical engineer. He shouldn't be testifying to this. This is not his expertise, and he's not a medical expert either. So this is out of his range. The witness says, it certainly would be consistent with the position we find the bodies in my scenario. Ms. Abramson says, excuse me, could I have a line indication of where that testimony supposedly is on 123? Mr. Khan says, it's on page 123. Ms. Abramson says, if counsel would wait for a minute, I'm not seeing it. The court says the question has already been asked and the witness has given his answer. You can cover it on recross if there's some area to be covered. Next question. Okay, but how's she going to cover it if she can't find it, Your Honor? If you ever think sometimes the judge is playing just one side, you might be right. Mr. Khan says, now, in regard to the wound to the left elbow of Jose Menendez, you said that you did not accept the testimony of Dr. Lawrence if he did so testify that the pellets bounced off or fell off from the left elbow of Jose Menendez. Can you tell us why you reject that proposition? Velocity of, pellets that had not been slowed down by something else would be so great, pellets do not bounce off, especially at this size, unless they had been slowed down by something. They have a factor of 76 times more velocity and probably, 30 or 40 times more energy than they need to penetrate skin, freshly shot, unencumbered. And in addition to your own conclusion rejecting that theory, do you recall reading any medical opinion that you relied upon of Dr. Golden at the trial which assists you in concluding that the 4 pellet defects are not the consequence of 4 pellets that bounced off the arm? I can't quote the transcript to you, but Ms. Abramson says, I'm going to object then, Your Honor, since the question requires him to talk about what he relied on in the transcript. Overruled. The witness says there was discussion of the defects being perhaps entry or exit, and I think it is important that the difference between the count in the X-ray pellets and the count of defects by an even number. Ms. Abramson says, excuse me, Your Honor, move to strike that part as non-responsive to the question about Dr. Golden's testimony. Sustained. The answer is stricken. Finally a win. Okay. What I'm asking you now, do you recall Dr. Golden testifying in the first trial that the pellet, Ms. Abramson says, I'm going to object counsel reading unless he gives me a paged cite. And Mr. Khan says 9235. The court says, let counsel find it. Okay, finally, you're seeing that, he's just going on and on without, allowing the defense attorney to catch up. Ms. Abramson says, well, Your Honor, I'm going to object. This does not, first of all, 9235 doesn't say anything about that, but the cite is erroneous. And what counsel is saying about it, I don't believe. The court says, He hasn't said anything yet. Ms. Abramson says, would you like to see it, Your Honor? The court says, no, the question hasn't been asked yet. Ms. Abramson says, well, the court says, we'll listen to the question first. Mr. Khan says, do you recall Dr. Golden testifying in the first trial that the pellets to the left arm could have passed through that elbow and continued on into the body of Kitty Menendez? Ms. Abramson says, objection, Your Honor, misstates the testimony, and it's at 9234. The court says, all right, let's get the exact question and the exact answer, Mr. Khan, if you have it. Mr. Khan says, yes. The court says, do you have the transcript? Mr. Khan says, I don't have it. I don't know that I have it. Ms. Abramson says, I'll give counsel my copy if you want to. Ms. Nahara says, here it is. Mr. Khan says, do you recall Dr. Golden testifying in the first trial, quote, question, and it's possible that four of those pellets passed through that left arm, continued on into her, correct? Answer, it's possible. Yes, I did read that part, that page of his testimony. It was one of those provided to me. And does that assist you in your illustration depicting the wounds to both the left and the right arm of Jose Menendez and the breast of Kitty Menendez? Partially. I believe that you testified that Dr. Golden did not agree with your opinion that the wounds to Jose's upper right arm were caused by the same shot. Do you recall that? Yes. And was Dr. Golden consistent, or has he been consistent in his opinion that those wounds to the upper right arm were not all caused by the same shot? Ms. Abramson says, I'm going to object as calling for speculation and conclusion by the witness. The court says, in reference to things that this witness has read that has been either written by Dr. Golden or testified to Dr. Golden, perhaps you can rephrase the question. Mr. Khan says, yes, directing your attention only to the original autopsy report and his testimony and his amendments to his original report. Has he been consistent in his opinion that the wounds were not caused by a single shot? Abramson says, again, I'm going to object because Dr. Golden wrote an amended report because of his misnomer. The court says, wait, counsel, don't make speeches. The question has been asked and the witness is being referred to various documents and he can look and see if anything in there refers to the question. The witness says, no, he has not. Mr. Khan says, and can you tell us how he has been inconsistent? In the original autopsy report, he refers to the individual pellet defects as entrance, and then he refers to the defect on the inside of the arm as the exit, and the defect back here is never mentioned. Okay, so now when you talk about the entrance wound, does Dr. Golden in the original 1989 autopsy report refer to the wound or to what he was saying was a wound at the time to the right forearm, to the bottom of the right forearm as being an entry wound? Yes, he has he has the individual defect on the inside as a number 2 shotgun wound. He has defects on the bottom side of the forearm as a number 3 shotgun wound, and he has this, he points, as the exit for number 2 or 3. The court says this being what? The witness says the big defect on the upper arm. I'm sorry, Your Honor. Mr. Khan says, let me clarify that a little bit further if I can. Shotgun wound number 2 in the original report referred to which wound? The original defects on the... Ms. Abramson says, Your Honor, I'm going to object to this witness. He cannot testify to what Dr. Golden had in his mind. All he can testify, court says he can testify to what he's referring to as the report that, as to the report that was the subject of cross-examination and part of the material that was relied upon in his opinions, which is what he's doing. He's referring to the report. By the way, I don't know if it's been mentioned here, but there's a differing number system used by the witness than was used by Dr. Golden and Dr. Lawrence in regard to the wounds. Perhaps you've noticed that in the testimony that the coroner in the initial report numbered the wounds a certain way. I think the evidence if it hasn't already been established, is that those are just arbitrary numbers that the coroner gives to wounds, labeling them 1, 2, 3, 4, 5, 6. You may know how to count without regard to any particular order that wound might have been inflicted. They arbitrarily select a number attributable to certain wounds, and I think there will be evidence about that later in the proceedings. Mr. Khan says, "Thank you." Who asked you to give that instruction? You just like off the cuff gave that, but all right. Mr. Khan says, "So, what Dr. Golden arbitrarily assigned to..." Ms. Abramson says, "Object to the form of the question, Your Honor." The court says, "Well, without reference to arbitrarily, just reference to the selection." Mr. Khan says, "Okay. What Dr. Golden designated as what you numbered as wound number 2 referred to which wound?" "The defects on the inside of the elbow." "Uh-huh. Right here on the right arm," and he points. "Okay. In this original autopsy report, he did indicate that that wound, the 6 individual pellets, may be related to the larger wound on the same arm." "Yes." "And in his supplemental report written in 1995, did he designate for the first time a new entrance wound to that arm which he had never previously designated in the preceding 6 years?" "Yes." Objection, Your Honor, calls for speculation on the witness's part. The court says, "All right, rephrase the question as far as the answer stricken in reference to designate. Perhaps you can refer to a particular document or testimony." "Yes." In his 1995 amendment, did he make reference to an entrance wound in the right arm, which he had not previously identified as an entrance wound in either his original report or during his testimony in the first trial? Ms. Abramson says, "Well, I'm going to object. This witness previously testified he doesn't know if he read the testimony in the first trial." Court says, "Overruled." The witness says, "And now I'm uncomfortable testifying about what the trial was because I can't recollect that well." Okay. Well, that's good because Ms. Aberson was calling you out on it anyways. Mr. Khan says, "Just let me focus. Let me focus you then on the difference between the original autopsy report in '89 and the amendment in '95. In the 1995 amendment, did he identify a wound as being an entrance wound which he had not previously identified in his original '89 report?" "He did." "And which one was that?" "He now identifies a defect on the upper right arm in back that he now calls an entrance for exit," and he points to an image or whatever he has as an example, one of the pieces of evidence that's up there, or maybe he points to his own arm. "These wounds are no longer discussed." We don't know where he pointed because it's not told to us. "And when you say they no longer are discussed, you're referring to wound. For the record, you're referring to what he had previously described as a wound to the right elbow. That is, I'm sorry, to the bottom of the right forearm. Is that correct?" Ms. Abramson says, "I'm going to object to leading." The court says, "Overruled." The witness says that the wound on the lower right forearm, the paragraphs are discussing, those are deleted, and there's no discussion of them in the restatement. Mr. Khan says, "So he deleted these wounds entirely from his report. Is that correct?" Your Honor, I'm going to object to the form of the question. Wounds aren't deleted, just the paragraph is deleted. Court says, rephrase the question. Mr. Khan says, yes, all reference to those wounds as exiting in the body of Jose Menendez was deleted in his 95 report or supplement. Is that correct? By his supplement, yes. Now directing your attention to the contact cheek wound to the body of Kitty Menendez, did you assume for purposes of your reconstruction that this wound was either antemortem, perimortem, or postmortem? No. For purposes of reconstruction, that's not an element. Did you review and consider the opinion of Dr. Golden in regard to this wound? Yes. And was Dr. Golden consistent in regards to that wound? Mr. Gessler says, objection, irrelevant, Your Honor. Overruled. The witness says no. Mr. Khan says, can you tell us how his opinion concerning that wound varied? Until very recently, that wound was before death. Abramson says, I'm going to object to that. He doesn't know what he's been saying for 6 years. The court says, all right, objection sustained. The answer stricken. Clarify what it is that's being referred to. Mr. Khan says, yes. That is, directing your attention to the original 89 report of Dr. Golden, did he refer to the wound, to all of the wounds to his body, to the body of Kitty Menendez as being ante-mortem in that report? Yes, unless otherwise specified. And did that report specify that the contact wound to her cheek was either perimortem or postmortem? He did not. Okay. Do you recall what his testimony was at trial concerning whether the wounds to the body of Kitty Menendez were antemortem or postmortem? Same objection. Court says, I think he's already expressed some discomfort in dealing with the trial testimony. Mr. Khan says, okay, directing your attention just to the 1995 supplement, did he change his opinion in that 95 supplement? Abramson says, objection, Your Honor, calls for speculation. Court says, are you asking, did he write something different in that report than he did in the earlier report? Mr. Khan says, yes. Did he? Yes. And what did he indicate in that 95 report? Now he's indicated that wounds could have been. Object to the answer, Your Honor, as speculation as to now. The court says, well, with the understanding he's referring to this supplement. The witness says, September 25th, 1995, he indicated the wounds could be perimortem or postmortem. Mr. Khan says, I do have a few questions. Does the court want to take a break at this time? The court says we'll recess until 1:30. Don't discuss the matter with anyone and don't form any final opinions. And we'll continue on with their, yeah, they're going into their lunch break. So we'll continue on with the afternoon session tomorrow. Thank you guys so much for watching. Please be sure to like, subscribe, share, and all the YouTubey things. And I will see you guys in the next one. Bye now.